Mr. Feigenbaum?
Good morning, Justices, Counsel for the Commonwealth. May it please the Court, my name is Jonathan Feigenbaum, and I'm proud to represent the appellant Charles E. Andrews, a disabled veteran. The reason we're here before you 4 years later after Mr. Andrews had been unlawfully terminated is to ask this Court to enter an order in judgment undoing the errors made by the appointing authority, the Department of Revenue, compounded by the Civil Service Commission and then followed by the Superior Court. And we are asking that the Court enter judgment in Mr. Andrews' favor, reinstating him with back pay, benefits, interest, costs, and attorney's fees as allowed by law. In this case, all of the lower court, the Civil Service Commission, and the appointing authority made a plain error of law by permitting Mr. Andrews' termination in plain violation of the Civil Service statute, particularly Section 26, which has a special provision that I would suggest that the legislature enacted to jealously protect disabled veterans in times of layoff. In this case, the Department of Revenue was told that the legislature had not adequately funded certain positions within the Bureau of Special Investigations, and as a result was forced to lay off a significant number of employees. In so doing, the appointing authority, the Department of Revenue, elected to lay off all of the employees that were classified as Special Investigator AB, which I would suggest to the Court really is of no relevance, and retained...
Mr. Feigenbaum, can I just ask you about that? There's a finding before the, at the Civil Service Commission that the investigator C's did perform more complex assignments.
That is the finding, and let me answer it twofold. One, why I think it's irrelevant, and secondly, there wasn't substantial evidence to support that. In reviewing the transcript, the Civil Service Commission, or when the Court has the opportunity to review the transcript, the Civil Service Commission made that finding, but it was based on testimony of the then acting director, Mr. Guy Sasso, and in looking at what he testified to, he really couldn't support his contention that the work was more sophisticated. For example, he said, well, Special Investigator C testify in court. Mr. Andrews testified, well, so do ABs, and in fact, I've done it 200 times. And what's of particular note is that Mr. Sasso only served in that position for 1.5 years, and when he was asked specific questions about what the actual duties of Special Investigator C's were, and in particular, with regard to the 5 employees that were retained, he couldn't differentiate what was different. But let me suggest this to the Court. The real issue and where the mistake was made is that neither the Superior Court or the Civil Service Commission or the appointing authority focused on what we would call the owned position, tenured position. That is the only one that counts. And Mr. Andrews, along with the 5 individuals that were retained, are all identified by this number. It's on page 97 of the record appendix in the chart, E20Z05. That was the permanent appointment. Of the 5 employees that are identified as Special Investigator C, those were all provisional appointments. And between Section 26 of Chapter 31, Section 39, and I'd suggest even the Civil Service Commission's method of codifying those statutes in the PAR rules, Personnel Administration Rules 15, they all specifically state that you need to compare apples to apples and oranges to oranges. And what do I mean by that? Employees that are being looked at for purposes of layoff must be looked at in their permanent title, not the provisional title. Each of the 5 Special Investigator C's that were retained were all provisionally appointed. they held the exact same owned, tenured, or permanent title as Mr. Anders.
But those provisional appointments were made pursuant to a very specific process. I mean, there wasn't just somebody, the supervisor said, okay, you five, you're now provisionally appointed today to be X. This was a process that there exists for appointments pending a civil service exam, right?
I don't know the background, but there is a process to appoint people provisionally. And I can only comment in this sense that when the Civil Service Commission, in a more recent case from this summer that is cited to in the brief, and we provided a copy of that opinion, Shea versus the Department of Revenue, there is long commentary by the Civil Service Commission talking about how there has been a breakdown in the system.
Absolutely, and that is a very interesting opinion, and it details decades of abuse in the Department of Revenue that has nothing to do with this unit that you're talking about, a unit that was only in the Department of Revenue for a very short period of time. In fact, it seems to me the whole opinion turns on the fact that there hadn't been a civil service exam in 15 years or some terrific amount of time, and that there had been a whole series of decisions directed at the department for their failure and for the entire system's failure in that regard. But that's not your case. That seemed to be the basis for them saying, in that case, provisional appointments really make no difference because it's all a game. But not here. They didn't make that finding here. Quite the contrary.
Well, the finding wasn't made, but I'm suggesting it's a plain error of law. The legislature, if you look at Section 26, particularly the way it's codified, the section that says that a disabled veteran shall be retained in employment in preference to all other persons, including veterans, just sticks out like a sore thumb or like a neon sign.
Yeah, but that statement has been refined. That doesn't mean that somehow that person is the last one out the door. That person could replace the commissioner or a deputy commissioner. I mean, if you read it, it would seem to suggest that, you know, that person is the last one before they turn the lights out in the department, and that's clearly not the case.
Well, Your Honor, I would disagree with that because I think the way Section 26 is written, coupled with Section 39, and then if we take into the equation the PAR rules, the personal administration rules, Rule 15 specifically talks about employees are to be compared in their permanent titles. And in the case of it's from the late 90s, the Town of Dedham case, granted it's in a footnote, and the Commonwealth has commented on that and called it dicta, and I'd suggest people usually refer to things as dictas when they don't like the opinion. The part of the opinion that is more favorable is always referred to as the holding. I believe the appeals court went through the correct analysis and said you must compare permanent employees in times of layoff to each other. I would also suggest that when this court looked at Section 26 approximately 10 years ago in the Provencal versus Worcester case, the court said that implied certainly that disabled veterans are the last ones to go. It only seems fair that follows the legislative enactment in Section 26, and otherwise the system can be abused by the use of provisional appointments. People could be... The
system can be abused, and indeed that was exactly the basis of the Shea case, where the Civil Service Commission found that there had been abuses there. But that doesn't mean it's always abused. That doesn't mean it's meaningless.
I take it your point, Mr. Feigenbaum, is that you don't need a factual finding that a particular provisional appointment is an abusive appointment. I take it your argument is look at the plain language of Section 26, the Veterans Preference Statute, Section 39, which starts off all permanent employees, add that to the PAR, Rule 15, and what you're doing is saying, when you're in a layoff situation, whatever the provisional position might be, abusive or non-abusive, you disregard that and you look at what their permanent position is.
I'm in complete agreement with you, Your Honor.
It's not agreement. I'm just trying to state your argument.
Well, that is my argument.
Okay.
That there is a plain reading of the statute, and that this court is reviewing the case de novo and should enforce the plain reading of the statute. And I would further add that the PAR rules are an interpretation of that statute.
I understand that, but then we've got the commission interpreting the PAR rules, correct?
Well, I think the commissioner ignored the PAR rule. I really don't think that the commissioner looked at it appropriately, because what the commissioner decided was he could compare a provisional appointment to a permanent appointment because he focused on this definition of special investigator AB versus special investigator C, which really doesn't equate with the permanent or owned title. And on those grounds, there wasn't substantial evidence also to support his finding. And I would just say it's plain wrong in terms of the statute.
Would the Shea case have been decided differently if there had not been that history of abuse there?
I wasn't involved with it, so I can't say, but I don't think that makes any difference at all in terms of whether or not Section 26 has been interpreted correctly or incorrectly in the Andrews case.
You know what the Attorney General says? The Attorney General says is, look, if you accept your argument, what you're really permitting a disabled veteran to do is to bump up. That is to say, assuming that there is a difference between the A/B on the one hand and the C status on the other, that even if those are provisional, what that means is that you're pushing the disabled veteran up. I mean, another way to look at that is to say, no, what you're saying is, for layoff purposes, which have got nothing to do with job performance, they have to do with money in this case. What you have to do is look at what the permanent status is. That's what you're saying.
No, here's where I differ with you, Your Honor. Mr. Andrews could have been retained in his position of B. There was no reason to bump him up.
What the Attorney General is saying is, in effect, this is a bump up. And I take it your answer would be, no, it's not. It's just doing what the legislature said, look at the permanent positions.
That is what I am saying, that look at the permanent positions. And I am saying that I don't know if this is a bad colloquialism, but if the lights are going to be turned off, the last one to leave has to be the disabled veteran.
Can I ask you one other thing? It is correct that Section 39 starts off with the language permanent.
Yes, it does. If permanent employees and positions from the same title in a department unit are to be separated because of lack of work.
Now, so what the Attorney General again says is that doesn't distinguish between permanent and provisional. In other words, it simply doesn't address provisional.
That's the argument, but I think that ends up in abuse within the civil service system. If the idea behind the civil service system is to protect employees having permanent ranks, tenured ranks, owned ranks, and particularly in times of layoff, in order to jealously guard the protections that are envisioned by the statute, to remove the political process, to remove favoritism, one must look at employees only in their permanent titles. Otherwise, it's just ripe for abuse.
But if what you say is true, doesn't everybody, in fact, get moved down to AB? And if that happens, when the ABs are eliminated, why isn't everybody just voided out?
I don't follow when you say voided out.
If everybody's being considered as an AB,
yes.
If everybody is being sort of eliminated from their C status when this kind of situation occurs, I take it they eliminated all the ABs.
Correct.
So you're bringing everybody back down to an AB, and then the positions are eliminated. How do they get back up to a C again after this? Well, I think this calculation is made.
If the process had been done appropriately, there would somehow be a process to allow permanent A, B, C appointments, assuming that actually is a different owned title.
Sure. I just want to. I take it that if there, at least for purposes of argument, right, if there were a permanent position, if there were an employee holding a permanent position in C, right, you would say, fine, then you look at whether there's a difference between C and AB because you're looking at permanent employees, correct?
Correct. And
then if there are no permanents in C, you look to what their permanent title is. That ends up with arguably 6 people in AB. I know there were others. And then in cost cutting, maybe they would have, in response to Justice Spina's question, have eliminated all the ABs, or maybe they would then have to go through seniority, preference, whatever it is. I mean,
or just have a test. Just create a test for Cs and void everybody out.
Well, and this is a distinction that probably needs to be looked at. Were the positions actually eliminated or unfunded? And I suggest that makes a difference.
I thought they later eliminated the whole thing.
That is true. My second argument is that Mr. Andrews should have been able to bump anywhere in the department because the statute, at least in Section 1, defines the term, when I say the statute, Chapter 31,
right,
defines the term department so broadly and uses the term department. For example, he worked for the Department of Revenue, and I would suggest that the Herlihy case that I've cited to allowed a psychologist to bump all across the Department of Mental Health. Mr. Andrews should have been able to bump into any one of the, I think there were almost 47 different, we'll call divisions under the Commissioner of Revenue and umbrella. And he was not provided that opportunity. And I'd also suggest there were divisions that were sort of in his line of work, such as the Child Support Division.
Right.
There's a criminal division. There were opportunities that should have allowed him to bump across the board.
Does the record show that, in fact, there has been a test for this new position or the resulting position of C investigator?
No. And I'd also like to point out significance. The employees, and Mr. Andrews testified to this, and it's in the record, they never referred to themselves as A, B, or C's. This only arose at the time of termination. They referred to themselves by pay grades, 20s or 22.
But they had to apply for that, didn't they?
There's nothing in the record talking about the C's applying. Somehow they were provisionally appointed, and I don't think this is unusual in any position in the Commonwealth, as pointed out in the Shea case. The problem that the Commission talks about may not be unique to the Department of Revenue, where permanent positions are just not being filled. And I suggest that that doesn't excuse the conduct that's gone on, and it would be appropriate in this case to enforce Section 26, but in its plain terms.
Thank you, Mr.
Thank you. Thank you, Your Honor.
Ms. Rice?
May it please the Court, Juliana Rice, Assistant Attorney General for the Commissioner of Revenue and the Department of Revenue and the Civil Service Commission.
Ms. Rice, let me ask you right off the bat. I mean, you understand what the concern is here. I have to say I found it a little confusing that the judge, the Superior Court judge, when looking at whether or not there's any distinction, and I explain why this is of some concern, says Mr. Sasso testified that the Special Investigator C's performed more complex work than the ABs. On cross-examination, he did not have personal knowledge of any specific projects or work that these five had performed that was more complex than the plaintiff performed. In light of the testimony, the Court defers to the Commission. I mean, it strikes me that if you want to give meaning to what is the most powerful legislative statement, disabled veterans get preference, and we talk about permanent employees, why can we not assume that you are bypassing that as a really strong legislative, scheme by letting people be, given some other title that nobody knows how the work is different? There's nothing in the record. He just says it's more complex. Well, tell me how it's more complex. I don't have any personal knowledge.
What is in the record is the testimony of Mr. Sasso as well as the testimony of Mr. Andrews concerning the duties of both of the positions. What's also in the record is a detailed job specification for both positions that was before the Commission and supported the Commission's determination that the two positions were in fact separate and distinct. And that was
and what do you point to that says C is more complex than AB? I mean, assuming that, leaving aside the provisional permanent.
Yes, Your Honor, I'll point to the record starting at page 49, Exhibit 4 before the Commission, which is a multi-page document detailing the job duties of Special Investigator, starting with A/B and moving on to C. and detailing the supervisory responsibilities of C and the first line responsibilities of AB. And those job descriptions in that document were consistent with the testimony of Mr. Sasso, and as the commission found, the testimony of Mr. Andrews did not compel a different conclusion, and the Superior Court
So
properly...
the work is not different. One's a supervisor and one's a line?
That is a central distinction between the two positions. What was important to the Department of Revenue, and I believe there was evidence about this in the transcript, was that in a time of budgetary crisis, the Special Investigator C position was a revenue-generating position, which was important to the commission, or I'm sorry, to the department.
Of course it's important, but that's not what the legislature said. The legislature hasn't said the disabled veterans get preference unless the particular department wants to keep a civil section that is revenue generating. It hasn't said that.
The legislature has said that disabled veterans get preference, and get preference within their unit and title. Title, under the language of Section 39, which governs layoffs in this situation,
Which starts with permanent.
Permanent employees. And as I explained in my brief, a permanent employee in that context is contrary to a probationary employee. There's no argument that all employees at issue in this case...
So what are provisional employees?
The provisional refers to the appointment. I'm sorry, the promotional position. There's no such thing as a provisional employee in the context of this case. What the term would be is probationary employee, an employee who has been appointed.
The legislature has never addressed, as I understand it, what happens when you are provisional versus permanent.
I believe that the legislature has addressed it by not making a differentiation in the language of Section 39 between employees holding promotions provisionally and employees in their permanent titles.
What is the effect of having a provisional promotion? Why is the promotion not permanent?
The promotion is not permanent because it was not made after a civil service examination from a certified civil service list. Section 15 of Chapter 31 governs the use of provisional promotions in civil service and contains a number of checks on their use, including the approval by the personnel administrator, oversight by the Civil Service Commission, to ensure that those provisional promotional appointments are being used in conformance with the basic merit principles of Chapter 31.
And I take it they are, at least theoretically, they stay in effect until the next civil service exam.
Correct.
On the subject.
That's explicit in Section 15.
But according to the Shea case, you apparently don't have to have a civil service exam. You can just fill these positions provisionally.
According to the Shea case, the opposite. The Commission found in the Shea case that Section 15, as well as the basic merit principles of Chapter 31, were being trammeled by the overuse and long-standing overuse of provisional promotions within the Department of Revenue.
Is there any evidence in this case that any of the provisional Cs were in fact supervising any of the ABs?
Not beyond the testimony of Mr. Sasso.
Mr. Sasso, but that's my point. Mr. Sasso didn't testify to that. And he said, please explain. What are these 5 people doing that's different? And he said, don't have any information.
Mr. Sasso spoke generally about the positions and also...
But that's the whole point. The department put forward Mr. Sasso as the person who could explain. I mean, it seems to me that if he says, I just don't know, why is it not a reasonable inference that that in fact there was no difference?
Mr. Andrews did not testify to the contrary.
Mr. Andrews presumably doesn't have the burden of showing what somebody else is doing. He may know, from water cooler discussions, but he doesn't know what other people are doing. He's not supervising them.
Before the Commission, Your Honor, Mr. Andrews did have the burden of showing that the layoffs had been made in bad faith, and he failed to show that, according to the Commission.
But I'm looking at what the Commission said. And I'm trying to figure out if there's evidence to support what it found as a factual matter, and then how that feeds into the interpretation.
I'll just point, Your Honor, again to both the hearing testimony and Exhibit 4, which is a detailed explanation of the job specifications for both positions.
Could Mr. Andrews have applied for a C position on a provisional basis?
Mr. Andrews had a number of options open to him if he felt he should have been in a C position. First, he could have grieved either his lack of provisional promotion or the provisional promotions of the other ABs who were promoted to C. He could have sought a reclassification of his own position under Chapter 30, Section 49, which ultimately would be.
I saw that in the Attorney General's brief, and this is the question that came to my mind. Let us assume that a fair reading of the statute is that you have to look at the permanent classifications, and an employee, for very good and specific reasons, decides that it's either not worth his while, he's going to lose the grievance because he knows that these are favorites. I'm not saying that's this case. And decides it's not worth his while because what he's most concerned about is losing his job. He is not most concerned about earning, I don't know what the pay differential was, but $5,000 a year more. It could be more than that. Do you know what the pay differential is?
I don't, Your Honor.
But let's assume that it's, you know, a reasonably significant amount, but not huge, 5,000, 7,000, something like that. And he may say, not worth it for me to go through a grievance procedure. I've got good working relationships. But if the worst happens, because in my experience that has been what concerns employees the most, is that they would get laid off. Why? Because if you get laid off, not only do you lose your income, but you lose all the attendant benefits. And that's very, very serious. And so he says, look, this is not a problem because this is a provisional appointment. Looks at the statute, goes to consult a lawyer. The lawyer says, no, this applies to permanent employees. And he says, I'm not going to grieve. I mean, isn't that a reasonable reason for an employee not to grieve?
It's not a reasonable reading of the statute, Your Honor. And if he was so advised by counsel, I would say that was faulty advice. There's nothing in Section 39 or any other part of Chapter 31 that differentiates between permanent employees holding their positions provisionally and permanent employees holding their positions permanently for purposes of layoff. Mr. Andrews seeks to insert that language into Chapter 39 out of whole cloth. It isn't there.
It seems to me that the Attorney General or the Commissioner is saying, you know, we just do it differently. The legislature didn't address it, so you have to treat it differently.
I don't agree. I think the legislature would have addressed it in Section 39 if it wished that in times of budgetary difficulty, all persons holding provisional appointments would be bumped back to their permanent appointment for purposes of ordering layoffs.
They're being viewed as permanent employees in what their permanent title is.
Section 15 is the section that governs the use of provisional appointments, and as I've stated, is quite specific in when and for what purpose and the length of time that those can be used. The Commission made no finding here, in contrast to the findings in the Shea case, that Section 15 had been violated by the use of provisional promotions within the Bureau of Special Investigation. It's important to note that at the time the Bureau of Special Investigations came into the Department of Revenue in 1999, all persons holding these positions, both provisionally and permanent, were the same as at the time the layoffs occurred in early 2002. The Bureau had been within the Department of Public Safety since before at least 1993 when Mr. Andrews became employed, and the Department of Revenue made no provisional appointments, made no changes to existing employment status of those employees at all until February of 2002 when it instituted budget-based layoffs. The Commission found that that was an important distinction, that distinction is apparent in comparing the Shea case and the Andrews case at the Commission level, where other parts, in this case the tax examiner titles within the Department of Revenue, which is an entirely separate type of function, had suffered, and the basic merit principles of Chapter 31 had been undermined by the longstanding failure for a promotional examination to be given. In this case,
Ms. Glass, can I just ask you, as I understand it, Section 15 was enacted was added in 1978, correct?
It was added at the same time Section 26 was amended. That's correct, Your Honor. As I stated, there's no allegation here that any of the retained Special Investigators C were promoted or retained in violation of Section 15, and the Commission did not so find. The
You mean they made no findings about it at all, or
They just didn't address the
they
question.
didn't address it?
There was no allegation that Section 15 had been violated, and therefore the Commission did not address it. The Commission did make such a finding in its decision in the Shea case. The Shea case, I'll just state, is currently under judicial review. Papers were filed in late February, and the case has not been scheduled for argument yet. But even if this court were to find an inconsistency in the Commission's decisions in Shea and in Andrews, we submit that the effect of such an inconsistency is not clear, and Mr. Andrews cites no authority for the proposition that the reversal of the Andrews case, which came first, would be warranted by such an inconsistency.
Remind me, how many investigators were laid off due to budgetary constraints?
The record shows only the total number of employees who were laid off, which was somewhere in the 60s.
But how many, you don't know how many, well, all of the AB investigators were laid off.
That's correct. The list, as Mr. Feigenbaum pointed out, is contained on pages 96 and 97 of the record of all the special investigators within the Bureau of Special Investigations A through D. And I'd like to make a point about the remedy sought by Mr. Andrews here. He was laid off in March of 2002. As of August of 2002, the Bureau of Special Investigations had been moved to the State Auditor's Office, which is not a civil service agency, and by the statute that moved, or the act of resolve that moved, the Bureau specifies that those positions are no longer protected by civil service. So at most, the special investigators C, who were retained when Mr. Andrews was laid off, were retained till sometime in August.
And how many of them went over to the State Auditor's Office?
It was moved over as of July 1st.
And how many of the Cs went over to the State Auditor's Office?
I believe 5 or 6.
So the 5 that are at issue here went over to the State
I
Auditor?
believe, yes, 5. That's my understanding.
And did I read the record right that they were then all laid off as well?
Correct, in August of 2002.
So they
By
went
the
over for
state?
about a month.
Correct,
By the State Auditor's Office?
correct. I'll just like to address briefly the Provençal case raised by my brother. That case,
You have 3 seconds in which to do that.
thank you, that case very specifically states that Section 26 does not, has to be read in harmony with other sections of the Civil Service statute. Was correctly done there and was correctly done here. And because the Superior Court was right in affirming the Civil Service Commission's decision, we ask for an affirmance.
Thank you,
you.
Ms. Rice. We'll take a short break.
All right.